We're here to talk about online access to court records. We have a terrific panel on this. My name is Jim Hemphill. I'm a litigator at the law firm of Graves, Doherty, Heron & Moody here in Austin. I do trial and appellate work, including First Amendment and government access work, and I'm vice president of the Freedom of Information Foundation of Texas, which is putting on today's conference. Thank you all for coming, and I'd like to thank the panel, and let me introduce them briefly. First, we have Mr. Blake Hawthorne. He's the clerk of the Supreme Court of Texas, thrice appointed as clerk, has served since 2006. He is a former assistant Texas Attorney General. He's been in private law practice in both Washington, D.C. and in Texas. He graduated from honors from the University of Texas School of Law. He's a member of the Texas Judicial Committee on Information Technology and chairs its electronic filing subcommittee. We also have Sharina Gilliland. Did I get that okay?
You did.
I did? Thank you. She is the Parker County, Texas District Clerk, has been since 2011. She has a bachelor's degree from Oklahoma State University and a law degree from Baylor University School of Law, a fellow double Big 12 graduate. Good to see that. Prior to taking office, she practiced law for about 10 years, primarily as a civil litigator, and she is here representing, at least in some capacity, the Texas District and County Clerks Association. We also have Madison Venza. She's the Southern Bureau Chief for Courthouse News Service, which many of us lawyers are very familiar with. It's an online news service for lawyers and the news media. She joined CNS in 2005 after working for 5 years as a reporter for Vanity Fair magazine in New York. She makes daily story assignments for reporters covering legal and political news in courthouses in a 7-state area: Texas, Oklahoma, Arkansas, Louisiana, Mississippi, Alabama, and Tennessee. We also will have joining us Representative Travis Clardy. As you might or might not know, Austin has a little bit of a traffic issue, and Representative Clardy is currently experiencing that, but he will be joining us in progress. He represents Texas House District 11, which includes portions of Cherokee, Nacogdoches, and Rusk counties. He's vice chair of the Local and Consent Calendars Committee and serves on the Higher Education and Energy Resources Committees. He's been recognized for work on behalf of law enforcement, rural health care, and constitutional rights. And outside of the legislature, he practices law at the very fine Texas law firm Kelly, Hart, and Holman. So I'm going to get right to the panel, and I'm going to start with Blake. If you could just give us a little background on electronic filing of court documents in Texas, how that plays into online access of court documents, and what the current status is, how the press and public can access documents online. And one thing I want to say before I get to that is I have to give great respect to the Texas Supreme Court for its level of transparency. Possibly the most transparent court in Texas, as transparent as any that I'm aware of. Even the oral arguments are live streamed and archived, so you can see video of it. It's, in my opinion, one of the great shames of the country that we can't say that about the United States Supreme Court, but it's very, very gratifying to see the level of transparency that we see from the Texas Supreme Court. So Blake, if you could tell us a little bit about online filing and how that plays into online access to court records in Texas.
Sure, so I'll start where I began with the court. Back in 2005, we had basically just docket information online. And just sort of by way of helping you understand how that online access works, every court has what we call a case management system. It's essentially the software that we use to track cases. And back then, we had no electronic filing at the Supreme Court. There was some voluntary electronic filing in some of our trial courts. But over the years, we found that voluntary wasn't going to work. And some courts just didn't want to do it. Some attorneys didn't welcome the change either. And so eventually, we mandated electronic filing first in civil cases and now in criminal cases. So criminal electronic filing, mandatory electronic filing is now just being rolled out in the state, and I think in a couple of years that will be complete, and we'll have mandatory electronic filing of criminal cases in all of our state courts. The federal courts, I'm sure many of you are familiar with the PACER system, the Public Access to Court Electronic Records system. Some of you may love it, some of you may hate it, I don't know. But we don't have a system like that yet in Texas, and that's where we're hoping to get to, and I'll talk a little bit more about that. But beginning with electronic filing at the Supreme Court, we eventually mandated it at the Supreme Court before we mandated it around the state. And what that allowed us to do then was to put all the records that are filed in every case online. So now there are exceptions, of course. I mean, if a document is sealed or otherwise confidential, we don't, because of state law, we don't put it online. But you can go to our website and you can see every single case that's been filed with the court. You can see every document that's publicly accessible is online. And that, to me, is where I'd like to see our courts be. I think it's good for the court. I think that this previous panel was talking about showing your work, right? As a reporter, if you want to put your sources out there and show people where you got the information from, it's I think it's important for people's confidence in the court system that they are able to see our work. They're able to see what both sides argued. At the Supreme Court, we go even further than that. If you call my office and you want to talk to one of my staff members about a case, we actually put that phone call into our system that someone called and talked to us about a case. I think one of the great benefits of that level of transparency is I have fewer and fewer people calling me and asking me for favors because they know that whatever it is that they're calling to talk to me about, I'm going to note that in the system and everybody's going to be able to see it. So that's where the Supreme Court is. We put every case type out there. I should add that we do have rules of civil procedure that require attorneys to redact certain information. So, for example, Social Security numbers, bank account numbers, information like that. The downside for the clerk's offices is that what do you do when they don't comply with the rules? And so in one way, it has made things easier for us because you no longer have to call us or come visit us to get copies. But then the downside is that we now have to enforce some of these rules to make sure that we're protecting privacy, and I'm sure that Sherry will have more to talk about in that regard. So most of our courts of appeals, we have 14 courts of appeals in the state. They have a similar website to the Supreme Court. They're using the same case management system that the Supreme Court uses. And they have a similar level of access to their court records. There is one court, though, that refuses to put, appellate court that refuses to put any records online, and that's the 10th Court of Appeals in Waco. So you can go there and see docket information, but they've decided they do not want to put any public filings online. When you get to the trial courts, the situation currently is that whether you have access to the actual documents that are filed in cases or docket information varies from county to county. Texas doesn't really have I would say, a central funding mechanism for our state courts. Much of our funding is done on the local level. We elect most of our local judicial officials. Sherry has to run for election. I'm thankful that I don't. I'm appointed by the court. And so much of the decisions are made on the local level. And I think as we begin to talk a little bit here about where we're trying to go, I think you'll see how this dynamic kind of plays out between the Supreme Court, which I think is what we're trying to do, I think, is make things more uniform across the state, particularly with regards to public access and the concerns from the local level about their ability to control their own access systems and their own concerns about privacy. So I think what brings us here today, though, is that we've been working with the Office of Court Administration and a group called the Judicial Committee on Information Technology, which is a group of lawyers and judges and clerks and other interested parties on a statewide access system that would bring the kind of one point of access that you have for the federal courts through the PACER system. This system has been dubbed Research Texas, and essentially the way it would operate is that when a clerk accepts a filing through the electronic filing system, that accepted filing is captured along with other information, metadata about that document and the case, and then we would create a docket, not the local court's docket, but a separate docket in this Research Texas system, so that you would have one place that you can go to search through all of our state court filings. A lot of the issues, though, of course, I mentioned privacy, I mentioned problems with enforcing redaction. There are other concerns that we have to think about in terms of what types of cases are we going to allow people to have access to. Do you allow the public to have access to family law cases, which by and large are divorce cases, adoption cases? I think most people would not like the idea of someone being able to log into a system and to find their divorce case. But then you have other people that take a different view and they think, well, it's a public record. I can go down to the courthouse and get it. Why shouldn't I be able to get it through this system? I don't think, though, that, just to be clear, I think that where the Judicial Committee on Information Technology is coming down is on some of these issues is that family law cases won't be available to the public through the system. Adoption cases won't be available. And there's a whole rubric that we've gone through to talk about, on case by case type, I should say, by case type, what types of cases will be available through the system. So that's kind of a general overview, I think, of where we are and what we're trying to do.
Thanks, Blake. That's an excellent overview, and one of the things that we will be talking about as this panel goes on are the complications in rolling out additional online access on levels of the trial courts and some of the courts that aren't the appellate courts, because the access for those courts presents a little bit different issue than some of the what we would call the ground level cases, like Blake explained. Right now, I'd like to go to Madison just for a perspective from a journalist and a member of the public about experience and access to court records both in Texas and other states, and why you think this is an important issue.
Sure, thank you. Well, as you mentioned, each court right now, all 254 counties have completely separate systems as far as how you can look at the documents. Some have online systems that are quite nice, where you can see same-day complaints the day they're filed. Others, it's much more of a challenge, and covering the news every day out of all 254 counties gets very tricky for reporters. What we've seen as the courts have transitioned from paper filing to e-filing is that several courts, like Harris County and Tarrant County, have really excelled with their online systems. Pretty much any given day, you could see any public record filed that day. But unfortunately, as all these courts have their own systems, they're not integrated, more often than not, we've seen a lot of regression in press and public access to documents with e-filing. Dallas County used to have fantastic access when the documents were paper filed, but they have really fallen behind where delays can be 1 to 3 or more days. And really, just like you wouldn't read a 3 or 4 day old newspaper, complaints lose their news value the longer they sit around before we're able to view them. Fast and open access to government records allows journalists to provide comprehensive coverage of what's going on. It's best if we can report the news as it's happening. And I think that cuts down on the so-called fake news, because if we can really see what's happening, there's not all of this hearsay about, oh, I heard something was filed, but where's the document? And then some news agencies start reporting things that didn't even happen. I will say some states have already successfully implemented statewide systems that work really well. Arkansas, back in 2012, started an online system slowly with just Little Rock. But now every county in the whole state is on there, and it's free to the public. You can look at any record the same day it's filed. Connecticut does the same thing. Every newly filed complaint is available. In Alabama, they have a system called Alicourt. E-filing is not mandatory there right now, but about 85% of all the documents are e-filed. All the e-filings are available the same day. And most of Mississippi is now on an online system where the documents are available same day. There are some other courts that have moved to providing the press with something called electronic inbox access. An electronic inbox sort of mirrors the old school press bin that you would find in courthouses when documents were paper filed. It was pretty much tradition. Once a complaint crossed the counter, it went into a bin, and it was there for press review before any sort of docketing or processing took place. Right now in New York, 22 of the 24 counties that are involved in their e-filing system provide the press with inbox access. So what that means is that the press is given a login, and they can basically log on to the case management system and see the documents before any processing has taken place. A lot of times there's no case number assigned yet. And then a few other individual state courts are moving in that direction as well. For a long time, we've had that kind of access in Clark County, Nevada, which is Las Vegas, and a few courts in the Atlanta area are also doing that, which are DeKalb and Fulton. Oh, and I forgot that Utah actually has a statewide system where the complaints instantly flow from their e-filing system onto a public system where anybody can view the documents.
All right, thank you. And we'll talk, I think, a little bit more about how some of those states might have dealt with some of the challenges that Texas faces in rolling this out. Let's go on to Sharina, because as someone who's on the ground level and is dealing with the complications that making online access available to documents from a variety of cases, and probably a large number of cases, that there are some challenges and obstacles to providing access. And if you could just elaborate some on some of the concerns about and some of the issues and challenges there are about providing broad public online access.
Yes, thank you. Well, as you know, there are 254 counties in Texas. Many of those counties have both an elected county clerk and an elected district clerk. A few counties have one person who is what we call a combination clerk, both the district and county clerk. So that's over 400 clerk offices. Texas is unique compared to some of the examples that Madison gave, in that the financial burden for maintaining court records since the beginning of time, really, in Texas, has fallen to the counties. And so it's the county's burden to provide storage space for paper records, as well as provide the funding for a case management system. And so that's why you see kind of a piecemeal across the state in what type of system each county has. For every feature that a county might have on their case management system, that's money being charged to the county that they have to pay for. So that's why you see a little bit different access and what's available online. As you all know, court records are public records. You can come in, look at the records, get copies. And I think the challenge right now is each county, again, is a little bit different in how you go about getting those. From the clerk's perspective, clerks tried their best to adopt and adapt to e-filing as quickly as they could. Civil e-filing, I think, went pretty smoothly and a little bit ahead of schedule. Criminal e-filing's been an option that counties could adopt. I'm proud to say our office was an early adopter of criminal e-filing, but that's starting to roll out across the state, and I think you'll see more and more courts come online with criminal e-filing. Where the clerks are getting concerned is the Research Texas element, the database portion, to be able to log in and see the records. And what we see in our courts, we see family cases, CPS cases, essentially it's everyone's worst day. That's what we see at the courthouse. You're having a really bad day if you're a party to a lawsuit or you're in a criminal action. From the clerk's perspective, these are our neighbors, so privacy, it's one thing for court records to be public, it's another thing for them to just be available worldwide on the web. Clerks, you may not know this, but clerks can have personal liability if information is released that's not supposed to be. So for example, if a document or case has been sealed or a case has been expunged and a person later suffers harm, a clerk could be held personally liable. We don't have immunity for that. So that's a concern in where we are with Research Texas is, are there enough checks and balances to make sure that documents that shouldn't be available to the public because they've been sealed or expunged are not available, but also checking for all of that personal sensitive data to make sure that that's not available online. Another big concern clerks have right now is maintaining this database. I think the clerks are concerned. We have responsibility, and our constitutional and statutory duties are to maintain the county records, which we're doing through paper or through our own case management systems. The concern is, in going forward, would there be some type of requirement for clerks to go into the Research Texas database to keep it updated? In other words, essentially having the responsibility to maintain two systems. And so that's a big concern for clerks, is to make sure that we're maintaining our system, we're maintaining our court records, but not being responsible for a state system and its upkeep. As Blake mentioned, there are rules in place regarding sensitive data. Enforcing those is a different animal altogether. I think the clerks, in appreciating what Research Texas is and what it can be, is they would like to see a go-forward date and really get that information out to attorneys, that everything you're e-filing is now going to be available online so that they can be more conscious and more aware of that sensitive data that's in their records and in their documents. Fees kind of became an issue. I don't think clerks in general are looking for copies to be a big moneymaker. Obviously, in some counties, they get more fees from their copies than in other counties, but that's something that's still kind of up in the air of what's happening with that. There would be some counties who would lose some revenue in copies. So while that's not a top of the list item for some counties, that is more important than others. When you talk about family cases, our office is now paperless, but we printed off a divorce that was filed in 2016, and everything that's green has sensitive data, as sensitive data is defined by the Supreme Court and in the e-filing rules. The white paper is stuff that does not have sensitive data. So this is a big challenge from the clerk's perspective. We have a lot of files that have this kind of information. And if it's just being captured, the records are just being captured when it's e-filed, how are these people's information going to be protected and not just essentially sold online? And particularly children. You know, divorce, in order to be enforceable, you got to have the kids' names, you got to have personal information in there to be enforceable. And I know Blake said there's discussions and considerations about not having certain case types available. And so obviously family cases present a whole wealth of personal information, but criminal cases do as well. You have victim information. You have the defendant's identifiers following arrests, even some civil cases. For example, personal injury cases, sometimes we see a lot of private medical information that gets filed into a case. So from the clerk's perspective, that's where we're coming at is privacy and liability and responsibility for maintaining this database.
Thank you. And I'd like to reinforce your point about, the people who are involved in matters of litigation are having a bad day. As a litigator, I say, people who come to me are unhappy, inevitably. They've either been sued or they've been done wrong and feel like they need to sue, and so that's kind of a fact of life. And the Research Texas that we're talking about, y'all may know this, but I think the way it's named is small letters RE:(S) search and then TX. Research Texas is the platform that they're working on rolling out, and I'd like to turn to Representative Clardy now as a lawyer and a legislator for his thoughts on this, including, this was a topic of discussion during the last session. I'd like to get your thoughts on the matter.
Sure. Thank you, Jim. And you're absolutely right. I just left a room full of unhappy people yesterday in a mediation in San Antonio that did not successfully mediate, but hope springs eternal. But you're right. That is oftentimes their worst day. And the pressure cooker is, in fact, the courthouse when these things happen. There's other issues we could discuss there about Second Amendment rights, et cetera, but we'll save that for another day. But I would like to talk about it was a matter of some discussion in the 85th legislature. I'd filed the House Bill 1258. It was euphemistically referred to throughout the Capitol as the Clerk's Bill. I was proud to work with the County District Clerks Association on that bill. It had broad support, and when I say broad support, I would say near unanimous support of the members of both the House and the Senate, but unfortunately for a variety of reasons, it hit the proverbial wall in the last few days of the session. But while others called it the Clerk's Bill, in my conversations with Chief Justice Hecht, I would refer to this as the Help Me, Help You bill. What we were trying to present to the court was a statutory framework that was going to have buy-in of the stakeholders. It really wasn't being achieved through the Judicial Committee on Information Technologies. There's discussions, there's conversations, there's things that said we're going to do these things, but then there aren't clearly defined answers. Madison, I was interested in what you said about some of the other states, and you mentioned Arkansas, that they started out. This makes sense to me. Let's start out with our largest city of Little Rock, and let's start with that county as the foundation, the base, and then we'll expand from there. And it took a 5-year period.
Yeah.
That's very closely to what we were proposing through House Bill 1258 and in the conversations we had through the movement of the bill. But let's start out with those counties that have, because of the population base, because of their economies, more resources to bring to bear to do the thing that we all want to do, and that is to make the records more accessible, more available, not only to the press, but to the citizens, to the public that truly own these records. The clerks don't claim any ownership of these records. Now, they are very protective of these. They can be a little, they have a little mother hen tendency to protect these records. But one is because that's their mission, that's their profession, that's their job. But it's also a matter of their oath that they took. These are constitutional positions. They are provided for in the Texas Constitution. When you are a district or a county clerk, you are an elected person. You are truly accountable to the people of your county on these records, not as the owner of the records, but as the custodian, as the steward of these records, and to protect these other interests. And so the men and women that serve as clerks throughout the state of Texas take this responsibility very seriously, have participated in good faith absolutely throughout the process of looking at going to Ray, Texas, or Research Texas, and have really wanted to do this in that spirit. But again, it's like my dad used to always say, if you're not going to do something right the first time, when are you ever going to find the time to do it right again? If you're going to do it, let's take the time to do it. This wasn't an effort to throw on the brakes, to throw a monkey in the wrench, to queer the deal, to slow this down, to keep this from ever happening. This was an attempt to let's do this in a way that makes sense with the people that are in the trenches, that are truly the tip of the spear in this endeavor, which are the clerks of the court that manage these records and know best how to deal with these issues, and their judges and the other personnel throughout the courthouse. And so what we were talking about doing was, again, let's focus on the major urban areas. Let's work through those kinks. And I will tell you, as a practicing lawyer, back in the day when we first introduced our e-filing, there were a lot of hiccups where, ooh, I filed that yesterday. No, you didn't click this button twice like you're supposed to, and your filing is now late. There were all sorts of problems as a practitioner and as a clerk and others. And over time, we worked through that. But we did that in kind of this is what I'm proposing, or what we propose in 1258, a staggered approach to allow the clerks to work through that. And it makes more sense, those larger counties with more resources, more personnel, to figure it out. Then as it expanded to the surrounding suburban, larger counties, and then to the mid-sized counties, and finally to the most rural, remote counties, by that time, a lot of those problems would have been solved, and the implementation would have been easier, and I think, by implication, less expensive to those counties with fewer resources. That makes sense to me. It always made sense to me, and that's what we wanted to do. One of the things, one of the roadblocks we hit, an amendment that I had originally in the bill and put back into the bill on the floor of the House, and it passed out, I don't know what the vote was, 130, 40, whatever it was, to, a handful, was to require negotiated rulemaking. And for those of you unfamiliar with that in the legislative process, what that necessitates is that the stakeholders, and the same people that sit on the JCIT committee would be the stakeholders, they have to meet and come up with solutions before they roll out the implementation. What I've seen, I will say firsthand from the one time I was able to attend a JCIT committee, is we'll get to that later. Let's vote on how we're going to do it now. We'll come up with the details later, but right now let's vote and approve it. And over the objections of the clerks and other members of that committee, let's go, 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 go. The old adage, haste makes waste, is applicable here. I think that you're seeing they're hitting hurdles and obstacles that frankly, that 1258 was designed to help you through, because by going through a negotiated rulemaking process, you think through problems better when everybody is pushing that out before you adopt them, rather than we've seen too many times in too many regulatory schemes in the state of Texas. An agency passes laws or guidelines, they're not statutes that pass through the process, come out as the promulgated rules of a particular agency, and the people who have to live with them pick them up and go, these are crazy, this won't work, and have very good reasonable objections to it, and you spend the next 2 or 3 years unwinding bad rules and replacing them with the rules that could have been done right in the first place. So that's really what we were driving at, and again, I was disappointed that didn't happen. It sounds like other progress has been made in other states, but as I have told folks before, if you want to make a bad pitch to a bunch of legislators, tell us that that's what somebody does in a bunch of other states, because this is Texas, and I really don't care what they do in other states. And so, I'm a confirmed believer that, inside every American, there's a Texan trying to get out. And so, when we look at what's happened here, I do think it's important to remember the reasonable and legitimate and constitutional reservations. I won't say objections. We want the transparency. We want the openness of the records. But Sharina mentioned the liability issue. That's a real concern, but that's not the first thing they're worried about. I'll promise you. The clerks haven't said, I'm worried about me getting sued. That's down the list of concerns. First and foremost, we are the stewards of these records. We have a duty to protect the privacy, as you mentioned, of the individual citizens. In some of the initial rollouts, there have been gross violations of the production and retention of records that were ordered to be sealed either by a specific court or under statute or improper to be released into the public domain. That has happened already. Those are the things that we're concerned about. One issue that you have to talk about, if you want to know the truth, you folks in the press, I know Brother Garrett down there would echo this. Sometimes if you want to know the truth, what do you follow? You follow the money. To this date, there is still not a clear explanation of how the money will flow. The representation has been made, the assurance has been made, and I'm sure in good faith, that the money that will come through the electronic system will more than replace and fund the counties better from the loss of revenue that would come from otherwise standing over a photocopier, making copies and handing them out. And there's probably a way that works, you know. There seem to be a lot of people making a lot of money with electronic stuff on the internet. So there's probably a way that makes sense in the real world. But no, I've yet to see it. I do know that there is a significant, what are we up to, 7, 8 figure, contract for these services to a particular vendor. But here's how the money will flow and flow back and be then divided up among the counties to replace that revenue has not been shown. The big difference between you'll hear the PACER system, the federal courts have done this. Well, there's a big difference between the federal courts and our courts. The federal government actually has the ability to print money. We do not have that in Texas, nor should we. But the federal court system is paid in whole by a single payor, being responsible to build out this system for the federal court system, for the PACER system, and it has worked well. I practice in both federal and state courts. But in the state system, we throw nickels around like manhole covers in the Texas legislature. And we don't like to appropriate money to things, and we do have a tendency of, whether wittingly or by design, pushing down the proverbial unfunded mandates to our counties. So in these mid to smaller sized counties, they do not have the resources. And so when you say about the regression, it's not a suppression or a desire to slow things down, but now you get it 3 days, where used to you get them a day later or the same day. The problem is now you've added another significant responsibility, and it has to be done by the same number of people, but you've given them no more money to do that or to hire the people to do those jobs. So surprise, when electronic information comes to you 3 days slower, you're back to the Pony Express. So I would say that until we solve the money problem, I think it's unrealistic. And again, I think I'm not a real smart guy, big brain, Supreme Court constitutional scholar, but at first glance, I would say there may be some constitutional issues when one branch of the government tells another branch of government and other constitutionally created offices, county judges, commissioners' courts, county and district clerks, they shall spend this money, yet they don't provide the money to do those things, and that would involve the legislative branch to do that. So again, there's a way to do this. We all want, I think, fundamentally the same thing: open and equal access to, and electronic access to the records. We would love to see that Texas court system move boldly into the 21st century. But let's do it right, and let's do it fair, and let's keep in mind that the people that we are sworn to protect, as a legislator, as a state rep, as a Supreme Court, or anyone else involved in the process, our duty is to the citizens of the state of Texas. And these are real and serious concerns that we have, and let's take our time. And again, if we're going to do it right, let's do it right the first time. So those are my rambling thoughts on the subject.
Well, thank you, and that gives it a great perspective. I mean, what we have, it seems to me, is a court system that, because of the size and other unique characteristics of Texas, is different than a lot of states, and it was not constructed in a manner that anticipated uniform online court access. So we've got a system, we've got rules about what can and can't be made public, then we've got arguments about what should and shouldn't be made public for the things that could be made public, and then we've got a system, a court system, that complicates any kind of uniform access. So with the bill in the last legislative session running up against the end of the session and not coming out, the question now is, how do we go forward? I know that those of us who are open government advocates, our default position is we want as much online as soon as possible, right? That's where we're coming from. And the folks who are charged with the constitutional responsibility of ensuring that all of the restrictions are met and all of the processes are met have their own obstacles. So where are we now? How do we go forward? Blake, do you have thoughts on that, on what comes next?
Well, I agree with a lot of what Representative Clardy said. I have to admit, being on sort of what felt like the receiving end of the legislation, I didn't always feel like we were on the same page, but I do think that we have the same goal. And I think that some of the other representatives in that process said as much. It sounds to us like, although you have some differences about how to get there, you have the same goal. And so I think sitting here today, I think we still have the same goal. And obviously, it's hard. None of this is easy. I would say that we've been talking about this here, access to court records, online court access to court records in Texas since the late 90s. It was actually Chief Justice Tom Phillips put together a commission back in the late 90s to address rules for online access to court records. So this has been, a very long process. And I don't know how quickly we're going to get Research Texas launched and have access for the general public, but obviously I hope that we can do it as quickly and as efficiently as possible. You're talking about other states. I heard a presentation from Florida, which is trying to do the same thing. They're following a very similar approach that we are. They have defined user roles. So if you're a judge or you're a lawyer or you're a member of the public, then your level of access is different, of course, right? Because if you're a judge, then you would probably have access to everything in your jurisdiction, or if you're a clerk, likewise. If you're a lawyer, obviously you need access to all your own cases, whether everybody else has access to them or not. So there are rules like that that I think we hope to put in place. And without a doubt, there's some technical issues that we need to overcome because the legislature in its infinite wisdom didn't fund a central case management system for all of our courts. But that's Texas, like the representative said. I mean, that's how we do it here, for better or for worse. And so we have to figure out a way to make it work. And I think we will. This is really, I think, democracy is messy sometimes, but I think the good thing about the clerk's efforts or the clerk's bill, Representative Clardy's efforts, is it really has, I think, focused a lot of attention on these important issues. And I think it's helped bring us to the table to talk about how we're going to resolve some of these issues. There's some technical solutions. There's some educational solutions, trying to get lawyers to comply with the rules. It's not always easy. But I think we're going to get there. And hopefully we can all work together and do it as efficiently as possible. I know the Supreme Court wants to do that. I want to do that. So I'm optimistic.
I'd like to make sure that we reserve a few minutes for questions, but just real quick, as the member of the panel who is more in the shoes of the public and the press, Madison, I'd just like to get your thoughts about what, based on what we've heard today about where we are in Texas and where we may or may not be going and what some of the challenges are, what your thoughts on that are.
Well, first I will say that as far as a member of the press, we don't normally cover any kind of family cases or the typical kinds of cases that have that sensitive information that they're talking about. I do think that a centralized system, however we get it done, would benefit everybody greatly because they can have a more thorough perspective of trends going on throughout the state and report just more effectively on what could happen based on the trends they see. It allows reporters to ask difficult questions from government officials and to really uncover what's going on in the courts reporters cover.
Yeah, if I could, Jim, I want to
absolutely.
add to what Madison just said. And what I think the goal of what we're doing through this process is to make these records open, available to all, not just the lawyers, not just the press, not just the courts, but to all citizens. One of the things, though, that we do talk about, and I will address this to our beleaguered members of the mainstream media, of traditional media, establishment media, whatever you want to call, One of the concerns that we do have, you mentioned that you don't typically report on family law matters, and that may be different depending on the venue you're in and wherever. But frankly, I've got no desire through this process to assist the up-and-coming TMZs of the media world, of the social media trolls who have no interest other than to muckrake and throw bombs at private citizens, and not just people who are running for office who would be likely targets of this activity, but also of just normal, regular people who happen to have been involved in a lawsuit 10 years ago, or had gone through a bankruptcy, or had been in a family law matter, or been some criminal allegation, whatever. One of the things we did talk about through the process and working with Mr. Hawthorne and others was, is to have the access relatively instantaneously of what's filed that's not subject to some protection, either court order or statutory. But those things, once those cases are filed, the final dates of appeal are off, that they drop off. The fear is, and I think this is a reasonable fear, how many times we've heard it, that once a record goes, once it's on the system, once it's on the network, it never goes away. A digital document never goes away. So on one hand, we're going to say, we're going to put this on there, but I don't really want to make this easy for someone who's just there with malintent. And again, not reporting on a serious story, discharging the duty that we appreciate under the First Amendment, but they're just to cause problems for people, being able to go back and look instantaneously at the comfort of their own living room. Here I find out everything I want to about Joe Blow and everything they've ever done. So how do you balance those interests between reasonable protection of privacy of individuals versus open information? And that's a challenge all of us are facing, not just in the media, but in the legislature and everything else. So I'm not giving a conclusion. I've just been running that around my head a little bit.
Sure. Well, thanks. All right. Questions, comments for our panelists? Let me go ahead and summarize the question then so everyone can hear. There are federal and state court rulings that talk about a constitutional right of access to court documents, both for the press and the public, and that right attaches at the time of filing, not at the time that it's later processed or anything like that. And while there is certainly a lot of attention being given to privacy concerns and constitutional and statutory privacy concerns, the question is the other side of that coin being considered in these deliberations and these discussions, which is the recognition of a First Amendment right of access to court filings by the press and the public. And I'll kind of just throw that open to whoever wants to field that.
Yeah, that's a great question. And you're absolutely right. As soon as we get something filed with us, you're absolutely entitled to a copy, to view it, take a copy with you without a delay in processing. I think where you see some of the, quote, delays in processing is counties that may be putting their records online. And so it needs to go through a review based on Texas Rules of Civil Procedure, Rule 21C, which lays out all the sensitive data rules. If something's going to be put out online, it cannot contain that sensitive data. The discussions we've had amongst clerks, any kind of delays in getting that out online is due to that rule. So there's a little bit difference in when you say access. If you're in the office, it's immediate access. To put it out online, the clerks have a responsibility to make sure that they're not putting something out online with data that shouldn't be there. So the discussions I've heard about a delay are in that realm. But if you were in our office and we file it, you can stand right there and we'll make you a copy, and you're absolutely right, you're entitled to that. So I think it's just in terms of the access. I know there's certain things I love to have delivered to my inbox. When it happens, you get that email. And that's what I was talking about with those types of features in a case management system. Each of those kind of features costs money, or even access to log into a system and see what that county system. And those extra features, the costs for that are borne on the county. So it's one part the clerk feeling comfortable having that access, that they've got everything secured that needs to be secured, as well as convincing your commissioner's court to pay for those extra features. And that's where you get that piecemeal across the state.
I will say that Parker County does provide excellent access. I can say that from our own experience. But some of the courts that don't have online systems do not provide same-day access. So it's not everybody. You guys are excellent, but in Travis County, for example, we have to send a reporter to the courthouse every day to look at the new complaints filed. He looks at them on a computer system, and just depending on what's going on in the court that day, there's staffing issues, many other things that could be going on. He may see 60, 70% of the same things that are filed that day. He might see 20, and it fluctuates day to day.
But if I'm not mistaken, I think the law requires equal access to these documents, not instantaneous access to these documents or easy access to these documents. And so, as a for instance, one of the things, well, we don't want to have to drive to the fair city of Nacogdoches to go to the courthouse to look at these things. It's a lot easier to stay in the big city and punch it up online. But the fact remains, the records as filed are immediately available in that courthouse. It's just going to require a little more effort to go get it if that's something that you decide to do. But I think, again, that's why we're moving towards this more automated system, so it is at least more readily available. At least you do maybe some pre-screening of what you actually want to look at. But you know, right now everything is fully open, available at the courthouse, and that's the way that it has always been. And again, so I think there's full compliance with the law. But you know, how important is it to Texas, and how important is it to fund it to have it where people can do it in their bathrobe sitting at their home computer? You know, what's the value of that really to us? Is that where we need to be spending the dollars, or the county should be moving dollars, limited dollars over to that project? So that's kind of the rubber of the road issue to me.
To summarize, that it's not for a lot of journalists, and lots of issues are statewide issues in Texas, that access to remote locations, if you're a newspaper in San Antonio and you're writing about a statewide issue and you want some data from the Valley or from El Paso or from Dallas or from wherever, that it's not just a convenience, but it's also something that serves journalists' duty to inform the public fully and completely and in a timely fashion.
On the other hand, our good friends in San Antonio, where I just came from, we love in East Texas for them to venture out on the old Nacogdoches Road and come visit us and see us in the hinterlands and come see what the rest of Texas looks like. So we want you to visit and come to our courthouses and stay in our hotels and eat in our restaurants and share your knowledge. We're sponges. We're here to learn.
One thing I do want to clarify on the funding issue is that this system has already been paid for, and it's been paid for by the attorneys who pay a fee every time they file a case. It's part of the contract that we have for the electronic filing system. So we don't need additional funding to make the Research Texas system happen. It's been paid for. What I think, though, the point, though, about maybe additional work, additional money needed on the local level is that what we're talking about here is a mechanism by which the clerks don't have to be in two systems. So in other words, they can control the content of what's in Research Texas through their own case management system. That'll take some work, and there may be a need for some additional funding there. And I know we'd all love to get that additional funding and get that work done. But I also, though, on the point about going to Nacogdoches, I think really what I'm experiencing with people, especially people representing themselves, is that how they are doing business these days is more and more electronic. It's more and more through their phones. I mean, even people who have not a lot of income now have a phone. And many of them are doing their shopping, their interacting with their schools, and other things through their phones. I think our courts have been somewhat slow to adopt to technology and to really give the public the level of service, customer service, that they've come to expect. I think that the public now has an expectation that they're going to be able to see their own cases online. They're not even going to have to take a 15-minute drive to go down to the courthouse to wait in line to see these things. I feel like we can do better than that, and that we owe it to the public, just as we were talking about how we owe it to the public to protect their privacy, we owe it to the public and to you all to deliver better services. I have heard judges over the years lament how there are fewer and fewer cases being filed in court. And as someone that deals with people that are representing themselves, I understand why that is. We're not making it easier for them, and we should be. We should be making it easier for the public, for attorneys, for the press to get access to these records. We shouldn't be making it harder.
Let me offer a different point of view as a practicing attorney, and actually not an appellate lawyer in the proverbial ivory towers, but in the trenches, in real cases, real courtrooms, real juries. It's one thing, and so to say the first part, you should be able to look at your own records that were filed in the courthouse as a party. I would call that a first party relationship. Well, that's your attorney's responsibility to keep the client informed and provide that information, and do that then now simultaneously, which is done via email between clients and lawyers, and to do that. So that's a different issue. What is a concern is what I mentioned a while ago. What happens if those records are 10 years old, somebody's just doing the muckraking, and you have what amounts to judicial voyeurism, where they just want to go into the court system and find stuff, not because they're participants or parties or even witnesses. They just want to look. They want to get in everybody else's business. Well, this isn't shopping for groceries. This isn't how do we go online to find a better deal for a car. This is the judicial system of the state of Texas. It is fundamentally different. This is how we get justice. And it seems to me, if we, in a rush to make this transparent and open, we run the risk of demeaning or denigrating the value and the importance of the court system. There's a reason our judges sit in benches that are taller than the rest of the room and wear robes, and that there is some pomp and circumstance and tradition and order that happens within a courtroom. That's what commands the respect, so when a ruling is made, the public respects it. But when we start treating the judicial system like we're selling used cars, we are creating a situation that, is that really what we want? And again, now these are two separate issues. The transparency and openness of records to the right people and under the right circumstances, subject to the law and privacy and confidentiality, is one thing. But we've seen too many of our institutions really drugged down in a cheapening of the civil discourse in this country in a lot of ways. Social media has not helped this. For all the great things, the ability and the ease of communications, we've also seen a downside to it. I think, our friends in the mainstream media have seen the usurpers to that crown of the true believers of the First Amendment, who don't follow your sense of ethics and journalistic integrity, and do those things and get a second source and corroborate your stories and before you put something out and publish it. So again, the world's moving faster than it ever has. So I just think there are things to think about. But I'm a true believer in the Seventh Amendment as well, and I'm a true believer in the court system. And nothing is more important to the continuation of this republic and of a democratic society than having fair and open courts and having respect for the rule of law. So let's don't get too big of a hurry here, folks. That would be my concern.
If I could make a point on that as well. Like what Representative Clardy was saying, a judge's day-to-day duty is first to decide a matter on a particular case. I think the clerks appreciate and understand the technology is moving forward, appreciate the online resources and desire for information, but we first have to think about these are real people with real legal issues happening, and the first order of business should be to fairly decide that matter. Secondly, becomes the convenience in getting records, or the ease of getting records. They are public. They are available at that moment. And so when we get into online access and things of that nature, that's where you see some of this pushback from the clerks is to say, hold on, before you just put everything out there. For example, in a family case, Do you all really need to know where my children go to school if there's a custody battle? No. It's public record. You can come look for it. You can come and find it. But if I were to find myself in that situation, is that something everybody in the whole world needs to know? No. That's where the clerks are coming at from the privacy aspect. And it's interesting, in this legislative session, we kind of had different philosophies butting heads. On the one hand, there's a desire to have more records online, and fully appreciate that. On the other hand, we had legislation passed that judges' addresses should be redacted from public records in order to better protect them. Again, do you need to know where the judge lives? That was presenting a security issue. There were a lot of bills filed regarding non-disclosure and expunction of criminal cases, essentially to try to help people get a second chance, that one criminal act or something that didn't result in a conviction is not going to prevent them from getting jobs or participating in their children's activities. And so a variety of bills were filed to either expand or clarify when can you have a non-disclosure and expunction on a criminal case. So it's an interesting dynamic back and forth. And I think what Representative Clardy is saying, and I fully agree, is first there's a duty to make sure that cases are decided based upon the facts and the law in that particular case. And that necessarily requires a lot of personal information happening. And then secondly, making those records available in an electronic world, but to do so in a very responsible manner that respects the citizens, that this is real life for them. It's not just gossip.
But it seems to me that, this is kind of an issue that involves so many other issues that are larger issues in the idea of online access to information and other fundamental issues. There's a separation of powers issue. There's whether or not there should be a right to be forgotten, as we see catching on in Europe. We talk about the difference between something being theoretically public in that you can walk into a courthouse, like I used to have to do when I was a reporter back when dinosaurs roamed the earth, that if I wanted to see what was filed in court, I had to go to the courthouse. Is there a difference between, a fundamental difference and a meaningful difference between being able to see it publicly that way and being able to just call it up on your computer? There's the issue of whether court systems are inherently different. The respect for court systems, does that require them to be treated differently than other governmental bodies? Lots of different perspectives here, and I think that will be an ongoing discussion. I'm glad that we had a panel that has differing perspectives, and I hope it's been valuable to you all, and I'd like to thank our panelists for coming today.